Next matter the court's going to take up, State of North Dakota versus Richard William Edders.
I'm disappointed that someone who was trusted to be a husband, a father, and a safe person in our home chose to cause harm instead. I'm disappointed that my children have to learn far too young what someone they should have been able to trust could betray that trust so completely. I also recognize that we share a child, and I believe that child should have the opportunity for whatever safe and appropriate relationship that with their father that may be possible. But maintaining that relationship cannot come at the expense of my other children or create an additional trauma and stress within our home. I also ask that the emotional safety of our shared child be considered in any contact or visitation involving his family or the people around him. I hope the sentence and the decision made moving forward reflect on the seriousness of what happened while allowing my children the safety and stability they need to heal and move forward.
Is there anything you would like the court to know in regard to sentencing specifically?
No.
Other than the portions you've just explained? Just okay. Nothing further, Your Honor.
Mr. Murphy.
Thank you. This is the second time in your lifetime that your partner's arrest has resulted in you having total possession of the family home, correct?
No.
I'm going to object on.
I didn't hear
that
I didn't hear the question, Mr. Murphy. Can you speak up, please?
Yeah, thank you. This is the second time your partner's arrest has resulted in you having total possession of the family home, correct?
No, this
I'm
is
going to object.
the first home
I'm
I've
going
ever
to
owned.
wait. I'm going to object. I know that the rules of evidence don't apply, but what in previous relationships has happened in a divorce has zero relevance in a case like today.
Your Honor, I think it holds a lot of
Stop.
relevance.
Mr. Murphy, it sounds like there's a relevance objection. The rules of evidence don't strictly apply, but they loosely apply. Can you tell me where you're going with this?
The investigation on this case never delved into background of the reporting side of the offense. This isn't the first time that this similar scenario has happened.
The states, can I respond to that?
No. I'm going to allow you to ask very limited questions about this, Mr. Murphy, because I find it of very limited probative value.
Basically, this isn't the first time, correct?
This is the first time. I've never owned a home before now. Or been on a loan ever before now.
No, that's not the question. The question was, it resulted in you having total possession of the family dwelling.
In like a divorce? So
No.
when I divorced my last person
No.
or
The
last
question,
ex?
the question was this. The arrest of your partner resulted in you having total possession of the family home.
That's never happened.
In Washington,
No.
your spouse wasn't arrested and resulting in your possession of the home?
No.
Can you describe what happened out there?
I'm going to object
In
again.
Washington with my first husband or my second husband. Richard is my third.
Second husband.
I object.
My second husband
Stop. State your
moved out of
stop,
the.
Stop.
Sorry.
State your objection.
I'm going to renew the objection on relevance, even loose relevance. Whether she gets possession of a home because somebody is arrested, she answered the question. If this court's response was she has a very limited area of relevance in relation to that, I think that's been answered. What has happened in her previous marriages, I don't think is relevant today.
Mr. Murphy.
Motivation for as long a sentence as she can get if it results in her possession of the marital home.
What sentencing factor does it approach? What sentencing factor does it make more or less true?
I don't have that reference, Your Honor. It just goes to credibility, Your Honor.
All right, I think credibility has been addressed, so I'll sustain the objection. You can move along.
There was testimony that your daughter heard the phone calls between Richard and his daughter, correct?
In the beginning when he was arrested, correct.
And you've allowed her to hear those conversations?
Not since then.
Is that an accurate statement that you told the investigator that maybe you shouldn't talk like that either?
Your Honor, we had a trial on this case and she was cross-examined on, in essence, the same things. I don't think the trial court has completely eliminated all of the testimony from their memory, and I didn't intend on retrying the case today either. The cross-examination is related to the victim impact
Can
statement. That's what
I
we're here
read
for.
Stop. Mr. Murphy.
this report is part of the PSI run. I wouldn't have had access to any of this prior to today, or prior to receiving this from out of the PSI addendum, Your Honor.
I'm gonna object to that as well. It's a law enforcement report that he received in discovery. He absolutely received that before today.
Mr. Murphy, what's its relevance to sentencing?
One of the things he's being sentenced on, vocabulary in the household, disorderly conduct, talking about shaving, that type of stuff, was noted in the testimony that that's just normal for the household.
That objection is sustained. Move along. Whether she did it to be clear for the record, justify Mr. Etter's conduct, which the court found to be beyond a reasonable doubt.
That's all I have, Your Honor.
There's only one person in this case responsible for criminal behavior, and that is the defendant. This case involves 3 separate victims, all of whom have been greatly affected by the defendant's choices in criminal behavior. These victims have something in common. Despite their age, and for 2 of them being siblings, they were all told by the defendant that they probably shouldn't tell anyone about what the defendant did to them. Why? Well, because he'd probably end up where he is today. Starting with the sexual assault charges, they're similar in that they come from the same day and event, but they're different in that they come from different victim perspectives. And they're also different because count 2 includes the defendant being a parent or guardian to the victim. As I said during trial, this wasn't a game of Candyland or Monopoly. This was deviant sexual crimes on repeat. The disorderly conduct of asking a child if she shaved, it included telling her that she had pretty feet, talking to the victim about her butt, talking to her about doing squats while she was working out in the garage, demonstrating an insinuation of oral sex while talking about watching her workout, telling her that she is, quote, his type, quote, and asking her if she shaves. The victim described these events in great detail during trial. The victim talked about these events happening in her kitchen, in her house, in rural locations while driving. All of these occurring in a place the victim was supposed to think of as home. There's no greater betrayal. That same standard applies to a step-parent. There's very few things more heinous than that, and the legislature seems to agree, as they have made this offense a Class A felony, the 2nd highest level offense in our state. A trial in which the defendant couldn't even put his antisocial ways aside throughout the trial. A trial in which the defendant simply defined his behavior as, well, sometimes I just do stupid stuff or say stupid stuff. This conduct is not nearly as simple or as innocent as the defendant would like the court to perceive it. Antisocial isn't just an opinion of the state either, it's a diagnosis the defendant has. Psychological evaluators of the defendant have said it's concerning the defendant has completed sex offender treatment twice, but continues to deny, minimize, blame victims, avoid responsibility, and show poor insight and judgment regarding appropriate sexual boundaries. Quote, his statements are not suggestive of a rehabilitated offender. It's a pretty bold statement from an evaluator, but it is one that's been opined of the defendant in an opinion that was filed with the court. With this antisocial came, as expected, 0 genuine remorse for his actions. The defendant has an excuse for everything. Who do we blame this on? Well, first his wife. She didn't give him enough attention. In one comment, the evaluator noted, the defendant acknowledged having thought about women and teenage girls in a sexual manner, but then noted that sexual attraction can be normative per the researchers if it is not acted upon. Well, here, it's clearly been acted upon for 2 of the victims, and he has acted upon it in the past with his prior offenses as well. This is concerning. The defendant also doesn't believe he needs treatment, and he said he doesn't need it because it makes him feel like less of a person. Well, the defendant's sexual assaults and GSI and disorderly comments probably made the victims all feel like less of a person too, so perhaps it's time for the defendant to start thinking about someone other than himself. He also tells the evaluator that his wife, the judicial system, the police, and the victims are included on the list of people to blame for these offenses. On count 1, I'd ask the court to sentence the defendant to 20 years with the Department of Corrections, first to serve 10 years, credit for 355 days, no good time calculation based on Baker, 10 years of supervised probation, lifetime sex offender registration. On count 2, 5 years with the Department of Corrections, to run consecutive to count 1, first to serve 3 years, credit 355.
Let the punishment fit the crime. Call a spade a spade. Horrible language that apparently the household got used to. People would say stuff, they would joke about stuff. It's in the report. Yeah, we used to joke around about that.
The sentencing hearing in case number 25 CR 43041, State of Ohio versus Stefan Scott, begins with Mr. Scott appearing before the court with his attorney, Mr. Ernst. The court confirms that the parties have had an opportunity to review the pre-sentence investigation report and then asks the state whether it is anything present before sentencing. The prosecutor, Ms. Nicholson, explains that the victim's mother is present and wishes to address the court first. The victim's mother tells the court that the defendant's conduct was not an isolated mistake, but something he had committed repeatedly. She emphasizes that the conduct was deliberate and that, even while facing charges in the present case, he committed the same type of offense again. In her view, this demonstrates a continuing pattern and a refusal to change his behavior. The victim's mother explains that what happened to her daughter has had lasting consequences. Her daughter had simply been doing her job when she was sexually violated, and since that incident she has experienced anxiety about going to work and has suffered nightmares. The mother stresses that her daughter's sense of safety was taken away in a place where she should have been able to feel secure, particularly because she was a teenager. She says that no one should have to fear being sexually exposed to while working, and that no family should have to watch their child struggle with anxiety, because another person repeatedly chose to behave in a sexually aggressive and unlawful manner. She expresses concern that without serious consequences, the defendant's behavior could continue and potentially escalate. According to her, his history demonstrates that lighter consequences have not stopped him. She therefore respectfully asks the court to impose the fullest sentence permitted by law, explaining that accountability is necessary not only for her daughter, but also to protect other women in the community. She concludes by thanking the court. The prosecutor then agrees with the victim's mother that the defendant's conduct represents a continuing pattern that has not been changed by previous consequences. She points to convictions from May 2019 and May 2023 and explains that he also received a conviction in November 2025 in Lebanon Municipal Court for another offense. According to the state, that offense occurred only days after the defendant had been arraigned in the present case in the lower court. The prosecutor explains that Mr. Scott had been given no bond and was held on the warrant at that point. Yet another offense was committed and later charged out of Lebanon Municipal Court. The state also notes that the defendant had been off probation for just over 2 weeks in the Brown County case when he committed the offense involved in the current matter. The prosecutor argues that the statements contained in the pre-sentence investigation demonstrate a complete lack of accountability. Based on the defendant's record and the repeated nature of the conduct, the state asks for the maximum period of incarceration. The prosecutor explains that the court is not required to impose community control and argues that Mr. Scott's history shows that he is not amenable or appropriate for community control. If the court were nevertheless to choose community control, the state asks that a no-contact order be imposed so the victim can go to work without having to fear further contact with the defendant. The prosecutor also addresses jail time credit and states that Mr. Scott should receive 4 days of credit on the present case. The prosecutor provides additional details concerning the defendant's custody history. She explains that he walked in on a warrant and initially had no bond set in Warren County Court, but he was not actually taken into custody on that matter. He was arrested on November 2nd for the Lebanon Municipal Court case. At his November 21st arraignment in the Common Pleas Court after indictment, a cash bond was issued in the present case. Mr. Scott posted that bond and was released on electronic monitoring on November 25th. The prosecutor therefore explains that he was not held on a bond related to the present incident until November 21st, 2025. After the state finishes, the court asks whether probation has anything further to add, and probation has nothing further. The court then turns to Mr. Scott's attorney. Defense counsel Mr. Ernst tells the court that he has remained in fairly constant contact with Mr. Scott since the incident. He acknowledges that Scott served time in jail, but argues that the experience created a change within him. He reminds the court that the defense had previously requested a modification of release conditions so Scott could work. Scott is employed at PX in town, and counsel explains that his employment has allowed him to remain current on child support for his 7-year-old son. The child support situation has been worked out so that he can remain employed and continue meeting his obligations. Defense counsel then describes several ways the present situation has affected Mr. Scott. He explains that Scott has been unable to see his 7-year-old son for approximately 4 months. According to counsel, the child's mother is not opposed to him and has not filed anything against him. Counsel also says that Scott has been unable to participate in sports activities he previously took part in. At the same time, Scott has expressed a desire to become more involved with faith-building church near the YMCA. Counsel says Scott has repeatedly emphasized the importance of being able to attend church, develop a supportive community, and strengthen his faith. He argues that throughout the case and incarceration, Scott has researched ways to improve himself and has repeatedly stated that he will participate in counseling. Defense counsel presents these points as evidence that something is different this time compared with the defendant's previous experiences. He says Scott has made a decision that he needs to address his problems and is willing to follow any recommendations the court makes. Counsel also emphasizes that incarceration has deprived Scott of the ability to help raise his son and says that loss has been painful for him. Counsel states that they respect the statements made to court and believe Scott supports everything he has presented. The judge then gives Mr. Scott an opportunity to speak for himself before sentence is imposed. Mr. Scott begins by apologizing. He says he has been trying to change and has been unable to return to church. He explains that he thinks about what happened every night and that the incident is constantly on his mind. He says he knows the pain he caused and wants to make things right. He repeatedly expresses remorse and says he does not want to continue living a life of sin because he believes he is better than that. He mentions again that he has not seen his son for 4 months, but acknowledges that the consequences are the result of his own actions. He says he wants to make things right, be present for his son, and stop letting people down. The judge then explains that the court has considered the statements made during the hearing, the pre-sentence investigation, the purposes and principles of sentencing, and the relevant seriousness and recidivism factors. The judge tells Mr. Scott that he has read the written statement Scott provided during the pre-sentence investigation and asks him to explain how that statement can be reconciled with what he is saying in court. Scott responds that he has a bad case of eczema and insists that he is not blaming the eczema for his conduct. He says that the actions were his responsibility, that he took the food, and that he immediately left. He also explains that he was embarrassed because his face had been widely displayed on Facebook and Instagram. The judge directly challenges this explanation. He says he does not understand what eczema has to do with Scott masturbating in front of a 15-year-old girl. The judge then points to an even more serious concern. This was not the first time. According to the judge, this was the 4th time Scott had been caught engaging in this type of behavior. The judge wonders how many additional incidents may have occurred in which victims were too embarrassed to come forward. He emphasizes the seriousness of repeatedly exposing himself and masturbating in front of young women, particularly while they were working. The judge tells Scott that he must reconcile the person he is presenting to the court today with the person described in the pre-sentence report. The judge explains that his concern is based on the fact that Scott is asking the court to believe that the current experience has finally been a wake-up call. Scott says he understands and insists that it will never happen again. However, he then repeats the explanation that it was not really a sexual act, but supposedly resulted from eczema, causing him to scratch himself to the point of ejaculation. The judge tells him that this explanation is extremely difficult to believe. The judge then gives Scott one final opportunity to explain himself. Scott responds by discussing the 24 days he spent in jail. He says he normally does not go to jail and that the experience exposed him to many things. He explains that he was already a believer in God, but while incarcerated, he encountered people who surrounded him with religious support. He mentions people from church and others who came to speak with inmates, giving him cards and small items that he could take with him after release to help him remain focused. He says that while in jail, he eventually formed prayer groups that met every night. He describes this as a calling and says he believes God placed him in jail to wake him up. According to Scott, he felt God's presence throughout his incarceration, and other people around him could sense it as well. He says they prayed after meals and before going to bed, and that his focus became centered on God. Scott tells the judge that he does not want to live a life of sin anymore or continue down a path that leads nowhere. He says he knows he is better than that and believes he now understands his calling. He emphasizes that he has always been a believer, but feels that being incarcerated placed him in a position